The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 948, coming to you on Monday the 9th of September 2019. On this program, I will speak to you on the topic adverse possession. But before getting into the topic, a few preliminary remarks, beginning as usual with expressions of condolence to those who have suffered recent bereavements. And I heard yesterday of the passing of one of our former Rockies residents, Vander Solin, well, the then Vander Solin. Secondly, I am sure our prayers have been going out for the people of the Bahamas who have suffered the ravages of Hurricane Dorian. When one sees the images of what destruction has been wrought in some of the Bahama Islands, one has to grieve for those people. The islands are generally flat. There's no such thing as mountains in the Bahamas. And the water just made a mess of the place to accompany the destruction by the wind. So I'm urging that whatever anyone can do to add to the relief efforts, if there are collections of money and supplies to be sent to the Bahamas, let us try our very best. Remember, it is not long ago that what was then Tropical Storm Dorian passed by St. Vincent and Grenadines and left us relatively unscathed. Unfortunately, it has slammed into the northern Bahama Islands, and it has now started doing damage to those states on the eastern seaboard of the United States of America. Let us hope for the best, and some of the forecasts indicate that the hurricane would tend to go north and then east and minimize the damage to those states on the eastern seaboard of the United States. So let us lift them up in our prayers. And now to the topic of the evening, adverse possession. I've spoken on this topic many times before, but there is one issue concerning adverse possession which I really need to repeat, clarify, emphasize, and drum home. Now, as we all should know by now, a law has been passed since 2004 making it possible for people who have occupied property, a house or house and land, for more than 12 years, subject to certain conditions, to claim that property as theirs after 12 years have passed. And the procedure begins with an application to the High Court, which has to be published in the newspapers, giving notice that such and such a person intends to apply for a certificate of possession of such and such a piece of land or property. and then several documents have to be filed. Well, the law which has made that possible, the Possession of Titles Act, has a definition of adverse possession. And that definition has several elements. Firstly, you have to show that you have been in adverse possession of the land, and you have to show that that adverse possession has lasted for at least 12 years before you made the application to the court. But this is the most significant part of the definition. If you intend to claim adverse possession of land or property, you have to show that your possession was as owner thereof. And that is what this program is going to clarify. So not because you occupied the place for 20, 30 years that you can claim it. You have to have occupied it as if you were the owner of it. And that is the essence of adverse possession. You have to have occupied it against the interest of some other party who was in a position originally to claim it. So in most cases, you cannot apply for family property, in most cases. Because if grandmother or grandfather or mother died, leaving a property for several children, and most of them go abroad, and one remains there. The one who is there, no matter for how long, ordinarily cannot claim it because that was family property, subject to what the law refers to as a trust. So once the land or property you are occupying has been left by a member of the family, and you are only one of the members of the family who is entitled to a share, not all of it. If you're entitled to a share in it, you cannot claim adverse possession, because you can't go in court and say, oh, you occupied it as the owner, when you know full well there were several other owners of the land in addition to yourself. Similarly, if somebody is going away and puts you in charge of their property, he tells you, look, take care of it for me until I come back. Suppose it's a house that needs repairs, and the person said, look, that's my house, I want you to live in it for me. I will send back some money to help repair it. And they don't send back the money. You think that could make you be in a position to claim it? No. You are not occupying the property as owner. You are occupying it as caretaker. And if you are taking care of somebody else's property, you cannot claim adverse possession of that property, because you are not there as owner. And I want to drum home the point, because every now and then somebody will come to me and they will say, well, Mr. Campbell, I've been living there for 15 years, 20 years, 25 years. So-and-so, they own it and put me in charge and go and say, They will send back money, may hear a thing from them, never wrote me and so on, and I'm claiming it. No. Once you are put in charge of the property as caretaker, then it doesn't matter how long the person has stayed away without writing to you or sending money for you to repair. You can't claim it. You can't go and file a possessory application and say you are claiming this through adverse possession. So, the law is that basically you can only file an application to get a title deed from the court in respect of property if you have been squatting on the property for more than 12 years before you apply. You may say, well, the law is giving rights to squatters and not to caretakers or family members, but that is the law. Adverse, in the phrase adverse possession, means against the interest of the rightful owner. Therefore, if you squat on property and you don't even know who the owner is, nobody knows whose property is, whose land it is, except that somebody might say, oh, so-and-so had owned it, but they went away years ago. You don't know the person. Person is a stranger to you. You go and you occupy because you see it's vacant land. And you occupy it, you cultivate the land, you reap the produce from the land. It has fruit trees, you reap the fruits, you sell them. You use the land as if it is yours. Then you are entitled to apply after 12 years to claim it because you have been squatting on the land for more than 12 years. Even if you know who the owner was, if you know full well this is, John Jones' land, and they go away, suppose they just go down to the Grenadines and they live down there, and you occupy the land, and John Jones doesn't take action to get you off, doesn't send you a lawyer letter to give you notice, look, you have been occupying my land, leave. And if you don't leave, carry to court. If he doesn't do that within 12 years, he loses the right to carry to court after 12 years. And you correspondingly get the right to claim a title deed from the court by virtue of 12 years adverse possession. Therefore, it is not just the fact that you have been occupying it for so many years. It has to do with the capacity in which you have occupied it. If you occupied it as a friend just looking after it for another friend or relative, you can't claim adverse possession. But if you occupy it as a stranger with no links to the rightful owner, then you can claim it, even if the rightful owner has a title deed for the property. And I want that point to really be understood. Even if somebody has a title deed for property, if they leave it and you occupy it for more than 12 years, as if you are the owner of it, you can go and file an application in court to claim the property. And when you put in the application and you put in your advertisement in the newspaper to say you have filed an application to claim such and such a piece of property, the rightful owner or the family of the rightful owner can come and make noise, and the rightful owner can through them or directly challenge you in court, because that is the purpose of you having to put notice in the newspaper that you are planning to apply, and the land has to be described in the notice so that world and country will know which piece of land it is. The law says anybody who challenges your application can come forward, file papers in opposition to your claim. So you claim, somebody challenges. Excuse me. They challenge by going to a lawyer, and the lawyer will fix up papers and so on and file their challenge. Eventually, the judge will hear the case, and the judge will listen to your side to see the basis on which you have claimed adverse possession of this piece of land and your witnesses. Then the judge will listen to the person who is opposing and their witnesses, and the judge will make a decision based on what the facts the judge believes to be true. Therefore, you cannot just say you have been living in a property or you have been working land for umpteen years and you are claiming it. It all depends on a lot of things. You have to show that you have been in possession of it. In other words, if it is land, you have to show you have been working the land. And if it comes to a contested application in court, the judge will want to know, can you provide proof that you've been working the land for all these years that you claim? You have to say what crops you grew, if possible, the names of the persons who you hired to work the land for you, and so on. If you can bring that sort of evidence to show that, yes, you did occupy the whole of the land you are claiming, you did cultivate it for your own benefit, and for more than 12 years, nobody took you to court to claim back the land, then you may well succeed in the application. Now let me make two further points. One, payment of land taxes. The law says that the payment of land taxes or the payment of property taxes does not prove that the person in whose name the taxes were paid was in possession of the land. Quite a lot of pieces of land have taxes paid in the name of a deceased person. So that if you're going away and you leave property and somebody starts squatting on the property, you could be sending back the money to pay the taxes year by year without fail. Ask your relatives to go down and pay these land taxes for your rear. Don't think that because you have the tax receipts, you would be able to resist an application by somebody who squatted on the land and claim possessory title. Similarly, Because somebody was paying taxes for a piece of land doesn't mean that they're in possession of the land. You see, if you cultivating a piece of land in the mountainside, which is yours, and you start paying taxes for another piece of land in the same mountainside, because you know that the owner of that land, went away or died or something, and you somehow start paying the taxes for the land, but you don't cultivate it, that does not help you to claim possession of it, because payment of taxes is not equivalent to possession. The law requires you to have actually occupied the land. Therefore, if all you did was pay the taxes, but you're not planting up the land, you're not reaping fruits on the land, you're not cultivating the land, you're not in control of the land, the taxes alone do not help you to claim it. You must remember that. Many people say, oh, here are my tax receipts, this is my land. The crucial question is, how long has somebody else been squatting on your land? Now, the second point I want to make is knowledge. If you knew that somebody is occupying property belonging to you, and even if you go to a lawyer to send them a lawyer letter to get them off, but they are occupying your property as if they are the owners, the sending of a lawyer letter, or you signing a letter and getting a justice of the peace to witness it, those things do not automatically amount to disturbing the possession of the squatter. The only thing the law regards as disturbing the squatter's possession is when you file a case in court claiming that you want your land from somebody who is squatting on it. So it doesn't matter how many lawyer letters you have written to the person in the past. Once you didn't go to court, then the law would not regard you as having done anything to disturb the adverse possession of the person who is actually occupying your land. You may say the law is funny. Well, it is. But you have a duty to check out the legal situation. Go to a lawyer and seek advice. Don't rely on a goatskin lawyer to tell you this and that. Always check a lawyer and get proper advice. Don't sit down and say, oh, you did think so and so. You could always sit down and think, but getting proper legal advice is absolutely vital to you in practically any situation of conflict. Many people have applied for certificates of title from the court, and the applications have been turned down by the court for various reasons. No two cases are identical. No two cases have identical facts. They may be similar. The principles, the legal principles are the same, but the facts, the situation of two people in conflict would not necessarily be identical to the situation of two other people in conflict over a different piece of land. So the fact that you hear so-and-so went to court and won doesn't necessarily mean that if you go to court, you will win. It all depends on what were the facts of the other person's cases and what was the law based on those facts. So don't say, well, me and Mr. Joe were in the same position. We both occupied other people's lands in the mountainside. He won his case and therefore he's supposed to win my case. Well, if the facts in your case are the same as the facts in Mr. Joe's case, and if the legal principles are the same, well then, if he wins, you will be likely to win as well, but not necessarily. Every case is slightly different from every other case. So I hope I have said enough to clarify the position. Always seek legal advice. If you go to a lawyer and you are still in any doubt, there's nothing wrong with seeking a second opinion from a different lawyer. Nothing wrong with that, once you have the money to pay for the consultation. Nothing wrong with getting a second opinion at all. If the second opinion is the same as the first opinion, well, then you'll practically be wasting money to look for a third opinion. Because if two lawyers tell you one thing about your situation, assuming you have told the lawyers the truth, it's hardly likely a third lawyer will tell you something different if you told the lawyer the same thing you told the first two lawyers. And remember, I'm always telling you, when you go to a lawyer, tell the lawyer the truth. Don't hold back and try to fool the lawyer by leaving out things which you know full well you ought to tell the lawyer. Let the lawyer know the actual truth. Otherwise, if you go to court based on information you have wrongly given to your lawyer, chances are you'd lose the case. Because the lawyer can only put forward what you tell the lawyer. The lawyer doesn't manufacture evidence. And contrary to what some people say, you tell the lawyer the truth and the lawyer will lie for you. That is not the case at all. Lawyers go by what their clients tell them. And if you lie to your lawyer, he will put forward a case based on the lie you have told him. And it won't be difficult for the judge or the other side to discover that your case is shaky because it's based on lies. Or you may tell the lawyer 90% of the truth, but you may chinks for 10%. Or you may tell the lawyer 99% of the truth, but chinks on 1%, hold back something or falsify information, and that 1% might cause you to lose the case. And losing a case in the High Court is an expensive proposition, because when you lose the case, most likely you have to pay the costs for the other side which has won the case. So you end up paying two lawyers, your own lawyer, and you end up having to pay the lawyer for the other side if you don't speak the truth to your lawyer. So it's no point going to a lawyer and tell the lawyer, oh, you have been occupying this place. The lawyer will ask you, well, who it came from and so on, and you conceal. Oh, say, well, look, this belonged to 4 parents who died a long time ago. And the lawyer will ask you, well, did they leave any children? No, my mother was the only child, and then my mother died and I'm the only child. Which and while your 4 parents had several children, and your mother may have had several children too, but you telling the lawyer was only you alone. And let the lawyer believe that you are the sole beneficiary. All right? All right, so I hope you are very much clearer now on the subject of adverse possession, and I hope you always remember that to claim property as an adverse possessor, you would have to have squatted on the property, occupied it without anybody's permission, as if it is yours for the requisite length of time, and have done so continuously. That is without interruption. Okay? All right, that is all from this program of the Law and You, program number 948. I look forward to being of further service to you next week, DV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, brothers and sisters, ladies and gentlemen, boys and girls, and may the good Lord continue to bless us all, and may He bless the people of the Bahamas and the affected persons in the United States of America in respect of Hurricane Dorian.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel R. Campbell QC and brought to you on SVG-TV as a public service.